are you logged in as published writer?
Oh, yes.
That
Let me
might-
go. Okay, let me go.
That's fine. I'll let you in now. We don't allow observations in Zoom. They have to go to YouTube. So let me let you in, okay?
Okay.
Okay. And then do you have a camera?
I do.
There. Okay. All right, perfect. So I know when we were here last, I had given Ms. Quinata some additional time. I know you had asked to speak with counsel. I haven't seen anything, so why don't I start with you on your ability to obtain counsel for today?
Sure. I decided, I already did everything that I needed to do.
Okay.
Sorry, can you hear me?
Yes, I can.
Okay. So I decided that I already filed everything that needed to be filed. I don't know. I can't remember first of all, I want to apologize because I wasn't feeling very well last time I was in court.
You are fine.
That's the first thing I want to say.
You are fine. You sound like you still might be a little bit sick, so.
A little bit, but I'm getting better. That's all that matters. I'm getting my voice back.
Good.
But I wanted to say that I already filed everything that I was supposed to, but I can't remember if I filed a roommate release. Matthew Posner actually moved out last year, and I took full responsibility of everything. So I did want to say that on record.
Okay.
And then I also filed a quick deed claim, and that's actually in Cowlitz County Auditor's Office already. And Elazar signed that. And he also did a warranty deed.
And
so I'm not exactly sure.
What was the date that was filed with the auditor?
I have getting older. Let me put these fancy bad boys on. 4/29. And the reason being is because I didn't have the money to file the paperwork. I am a single mom, and it's just Marley and I.
Did Ms. Radecki, did you receive that?
So, Your Honor, I received some deed from her. I don't recall if that was the date. I can check my inbox though. But there was nothing to do with her name, to the best of my recollection, on it, nor Mr. Jackson's interest conveyed to Ms. Kanata.
Okay. So it sounds like we're ready to move forward then. So Ms. Radecki, this is your motion, so I'll turn it over to you. And then Ms. Quinata, you will have the option and ability to respond.
Sure.
Okay, go ahead, Ms. Radecki.
Thank you, Your Honors. Plaintiff is Annette Jackson. We're seeking a preliminary injunction and a writ of ejectment today, so that my client can get her home back. In Washington, courts that assess a three-part test generally when trying to assess whether a preliminary injunction is appropriate. Those three prongs does the person have a clear right to possession? Is there a well-grounded fear or invasion of that right? And then the third one is is there continued injury resulting from defendant's unlawful occupancy? So ultimately, the relief that we are requesting today is immediate removal of defendants and any unauthorized occupants, in order prohibiting the defendants from taking, damaging, moving, or...
All right, folks, buckle up because today kicks off an entire week of wild court Karens, and this one is something else. We're talking about a woman squatting on her ex-boyfriend's property, a property he lost in a divorce, and she's convinced she has magical powers of real estate law. She's playing the fraudulent flavored Softic Kool-Aid game, thinking she can claim ownership with a deed she barely understands, while law enforcement and the courts are watching her every move. In this hearing, you're about to see a collision of delusion, bad legal strategy, and consequences waiting to happen. Trust me, the chaos starts now and it's going to get messy.
Of the premises, pursuant to a final divorce decree entered on August 26, 2024 in Cowlitz County. The cause number was 23-002-4408. That was attached as Exhibit D to our complaint. Defendants have never had a valid lease agreement, never have paid rent or a legal right to reside on the premises. The defendants had submitted a lease agreement. They purported it was valid, but it was not issued by Ms. Jackson, the plaintiff. It was not signed by her. Ultimately, they are not tenants. The defendants entered the premises without plaintiff's knowledge or consent after she was forced to leave the home due to domestic violence. RCW 7.28 supports plaintiff's legal right to possession as the record and sole title holder and the only legal owner to the property. Defendants don't assert any valid ownership rights or tenancy. They were at best holdover licensees, but now have been trespassers since they were served with the proper notice to vacate back in February of 2025. So moving on to the next factor, the well-founded fear of immediate invasion of the rights. Defendants remain in unlawful possession and continue inviting strangers onto the property. Law enforcement frequently visits the property. Plaintiff had visited the home in December of 2024 with law enforcement and discovered a number of concerning things, but especially highlighting missing personal property. Her dogs were locked inside the house without food or water, and there was just general disrepair and suspicious activity occurring inside the home. The continued occupation of the defendants prevents plaintiff from accessing, maintaining, or safeguarding her property, and has violated her rights as a property owner. So moving on to the third and final factor regarding the actual and substantial injury to the plaintiff. There has been ongoing economic and personal harm that the plaintiff, Ms. Jackson, has suffered from the inability to reside in her home. She's had to incur additional financial expenses to house herself elsewhere in the interim. Property has been missing and gone damaged inside her home, the property that's subject of the action. She does have concerns about the well-being and welfare of her animals and other personal property that she's not been able to observe in the past 6 months. And this has caused her a great deal of emotional distress, and she has safety concerns.
Out a textbook motion for ejectment, and you need to notice how meticulous this is. She walks the court through the 3 prongs for a preliminary injunction: clear legal right to possession, well-grounded fear of invasion, and continued injury from unlawful occupancy. This is critical because the law doesn't just remove people for being annoying, it requires proof. Every detail about unpaid rent, invalid leases, and previous notices establishes a strong legal foundation. Notice how the attorney contrasts legal reality with the defendant's fantasy, subtly showing how unprepared the squatter is to justify staying. This is the court hammering down the facts step by step.
About the property and welfare of everything there. Defendant's presence is causing continued deterioration and damages, and plaintiff is concerned about further damages if the preliminary injunction is not granted today. At this point, these injuries, a lot of them are irreparable and not compensable solely with monetary damages. So regarding the balance of equities, just to touch on that for the courts may weigh hardship when considering a preliminary injunction, but only for innocent parties generally. The defendants were warned of their status as trespassers and received a 3-day notice to quit on or about February 8th of 2025, but failed to vacate and clearly still occupied the premises. They knowingly remain without rights to do so, and Ms. Jackson is entitled to recover her property back and eject the defendant immediately without further delay. Plaintiff's hardship, loss of access to the property, damage to personal possessions, possibly her animals, and an inability to exercise ownership rights far outweighs any minimal inconvenience to the defendants at this point. They've had well over 3 months of notice to vacate and have still failed to do so or show any indication that that's their intention. At this point, we believe that the injunctive relief is appropriate as plaintiff has clearly satisfied all 3 factors: the clear legal right to possession as the sole owner, that she does have a well-grounded fear and immediate invasion of that right. There's continued injury resulting from defendant's unlawful occupancy of the premises. And courts may act to preserve the status quo and to prevent loss or damage during litigation. So we're requesting the courts to grant this preliminary injunction, to grant the order ejecting the defendants from further damage. And I did want to touch too on the bond requirement for Court Rule 65B. So it does require a bond unless it's waived. We would just simply request that the court waive the bond, but if the court is inclined to issue one, that it would be a minimal bond of just $100, due to the 2 main factors of there's a lack of lawful claim or tenancy of ownership or ownership by the defendants. There's no credible risk of this being a wrongful action at this point. And also we would reiterate a request for fees and costs associated with this action. So to sum up, we are just requesting that the court grant the order for the preliminary injunction, ejecting the defendants from the property immediately and enjoining them from interfering further with plaintiff's property or damaging it.
Now, let's pause here because the court commentator makes a key distinction: eviction versus ejection. Eviction is for someone with a legitimate lease or right, while ejection is for those with no claim whatsoever. And make no mistake, this isn't just semantics. It's the legal lever the plaintiff is using to regain her property immediately. Our court Karen here is in full adverse possession fantasy mode, thinking she can claim the property because she's been living there a few years and doing minor maintenance. But the law requires years of open, notorious, hostile use, and the court isn't impressed by fantasies or partial repairs. The reality is about to hit hard.
Adverse possession does require quite a lengthy period of open, notorious, hostile use. So if you want to start there, feel free.
Sure.
Go ahead.
Okay. First thing I want to say with the adverse possession, I've had to fix the furnace. I've had to fix everything on the maintenance side of that. I already mentioned that Matthew's not there. It's just me and my son. And I kind of took some notes a little bit, but I've been there for almost 3 years, going on 3 years. I don't know how long she's lived there. When Eleazar left, and I'm not part of their divorce case, so whatever property she had went with Eleazar, and whatever property she had went with her. So I don't have any of her property. The other thing is, ADT will verify that they never came and served me. And so I actually put up ADT systems because there were people that were coming to the house, and it was just Marley and I. And so I do have that. And then I also have that I was reaching out to her, and I posted notices, hey, what's going on? And that's verifiable through Woodland Police Department, because they had taken some reports and had said, we seen a notice on the door, and they actually verified that there wasn't public notice on the door and on the street side, so that she could see, hey, this is what I'm doing. Where do I pay my rent? What do I do? So I started that, I think, in September, after or whenever their divorce was. I started reaching out to her, and all I got was, I talked to, I always forget his name, the mayor of Woodland. Anyways, I was talking with him, and I said, is there a reason why all this is going on? And he said, well, she still owns the house. I go, I know, but I'm just trying to communicate with him. So he knows about the situation too. And then I also spoke with my son's advocate through missing and exploited children. I've been talking with her about it because Annette had installed cameras at the house, and that's why we ended up getting ADT. So I do have everything that is verifiable through Woodland Police Department, the mayor of Woodland, and through ADT, that I've never been served. I've never even received a notice saying, hey, new ownership. I've never received any of that. The only thing I received was an ejection. I was like, what is an ejection? I've never heard of it. So I had to do a little bit of research, and I understand what it is, but I'm not a squatter. I'm actually on a lease. I signed it with Eleazar. And I'm kind of glad I did, because that's how it started, was, that we were roommates, and then it went into this whole big thing, and I've been dragged into their divorce for no reason. I mean, I get and I understand, but I'm not part of that case. The case, like today, is just about the house. I'm on a lease. There was an adverse possession because I kept trying to reach out to her and put posting notices, and I didn't know how to contact her. Then after that, what else was going on? Basically, that's pretty much it. I mean, and then I said, and then that's right. I got a foreclosure notice on the door, and I was like, oh my gosh, what's going on? And so then I actually submitted the information to the mortgage company saying, hey, I'm right here. What can we do? And I filed and submitted a 1099A with them. And then that's when I asked Eleazar. He said he didn't want anything to do with that house. I said, okay, well, will you sign? I didn't know what kind of deed to sign from him. because I couldn't get a hold of Annette. And so then Elazar had signed all of them pretty much, because I put them together. I was like, I don't know, this is what the auditor's office is asking me for, but I did pay on the mortgage and the taxes. I did the last 2 years of taxes. I paid those off. And then I also did the mortgage. I made it, I have an agreement with the mortgage company. So she was already at default before I even made this decision or even decided to go into this position. So that's where I panicked, and that's where I started asking around and doing a little bit of research. And so that's where I'm at.
You're paying the mortgage every month?
No, I paid it.
Plaintiff highlights the real consequences: missing personal property, locked dogs, and general disrepair. This isn't just paperwork, it's tangible harm. Courts take this very seriously because property owners have rights to protect not only their belongings but also the safety of their animals. And here's the kicker: the defendants were warned back in February 2025, received formal notices, yet continue to occupy unlawfully. The court is basically being asked to step in before this turns into a full-blown disaster. This is where fantasy meets reality, and the stakes are personal, financial, and legal for everyone involved.
When was that?
I submitted it with the paperwork that I gave you guys. It is, hold on. Let's see. And actually it was more than what they, hold on it. Working in this little tiny spot, so hang on. It was paid on, of course I got a really bad copy. I'm gonna have to pull up the original document because this is really light, the one that I submitted. But if you don't mind waiting for just a moment, I can just grab my bag and pull it out. If you'd like me to grab that and tell you the date that I paid it.
Yeah, that would be helpful.
Okay, hang on just a moment. I dropped my box right before we started this, and it was with my paperwork, but the copy that I have, the hard copy, I just can't read the copy that I made you guys.
There's a 1099 that's of poor
It's
quality.
12/24/24. Sorry, I just got it.
December of 2024.
Yes.
And did you pay the $20,000 amount, or how much?
No,
did you
I paid 487. Wait, 400. Can't even read it. $418.79. I have $79.42. And then I also paid the taxes on it, and I can grab that.
So tell me the mortgage amount that you paid in total.
$418 and $70,000. Oh no, $418,079.
Okay.
Yeah.
Okay. And Ms. Radecki, your client does she agree with the fact that the mortgage was paid off?
No,
No, she does not. Okay.
that is news to me.
Yeah, and I don't have proof of that in the file, Ms. Quinata. Do you have a document there that shows?
It was on the 1099 because I had to file this with the IRS, and it's submitted as an attachment.
It's
attachment H.
I understand. So what I was telling you is you did submit a 1099 to us, but it's of such poor quality that none of the numbers are readable.
Okay.
It appears to be in handwriting. So the title of it says acquisition or abandonment of secured property. Right. That's not a receipt from the mortgage company that tells me that they've received payments.
I have a V and a B and a D, 10 and 8, all of those. Which actually so I've been talking with Freedom Mortgage, and somebody had submitted that some other mortgage had the deed, so I confirmed with Freedom Mortgage, and they were like, no.
Addresses the irreparable harm caused by this unlawful occupancy. Imagine being displaced, seeing your property damaged, paying for a new place to stay, and worrying about your pets, all while someone else just refuses to leave. This isn't just frustration, it's legally recognized as substantial injury. The court carefully weighs these factors because injunctions are about preventing further harm. And for the audience, take note, these types of hearings highlight why the law doesn't just rely on common sense or moral arguments. There's an established process for assessing risk, harm, and urgency, and the plaintiff is ticking every box.
Is that you clearly were aware that in September of 2024, in a final divorce decree, unlike what Mr. Jackson submitted to the mortgage company and clearly just a couple weeks ago to Cowlitz County, the divorce decree did not just state that Ms. Jackson was responsible for the payments. It stated that she was given the property.
Yeah.
And
I'm not.
well, hold on. So she was
Sure.
given possession of the property, and he was mandated to leave the property. And so first and foremost, I mean, I have some concerns about what's happening behind the scenes with Mr. Jackson towards this property, that he is telling state, county agencies that he has the right to this property. He does not. And you now have received through this lawsuit proof of that. You have not been in the property long enough to obtain it by adverse possession. Even if you had met all the other factors, you're not even close, frankly, timeline wise.
Right.
So there's no question in my mind that a preliminary injunction is necessary in this case. The only question for me is if a mortgage in the amount of $418,000 was paid,
right,
then I would be requiring a bond of more significance. And so I guess let me hear from Ms. Radecki first, but we need to figure out if there's been $418,000 paid towards the house. Ms. Radecki, I know you've already said kind of this is news